Hello, everyone. This is your girl, Ladydee. Hey, guys. I'm just signing on here. I'm gonna read the answer. R. Kelly filed a complaint against the United States of America, the BOP Officer A, and Miss unknown John and Jane Doe BOP officers, and also Latasha Kebe, also known as Tasha K, right? So on February 5th, which was what, Monday, they filed their answer. And I do have a copy and I'm going to read it. There was no need of coming live because you guys don't even conversate when I come live. So I'm just going to read it and leave your comments, okay? Again, this is the answer. The defendant, the United States of America, by its attorney. I'm not even reading all this shit, okay? This is the United States of America's answer to the complaint. First defense. Plaintiff claims against the United States is barred by the FTCA's discretionary function exception. Then it has a case statute here, cite. Second defense. Answering the specific allegations of the complaint, defendant admits, denies, or otherwise avers as follows. Introduction. So, the complaint. Plaintiff sues the United States of America unknown BOP officer, also known as Officer A, unknown John and Jane Doe BOP officers, and Latasha Kebe for distress. No, I'm sorry. And Latasha Kebe for negligence. And I'm sorry, guys. I'm working and the phone is ringing. Let me read that over. Complaint. Plaintiff sues the United States of America unknown BOP officer, also known as Officer A, unknown John and Jane Doe BOP officers, and Latasha Kebe for negligence, invasion of privacy, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton conduct brought under the Federal Tort Claims Act. Plaintiff also brings suit against defendant BOP Officer A for violation of the Computer Fraud and Abuse Act. Okay, so they stated what was in the complaint. Here's the government's response. Admit that the complaint purports to bring those allegations. They make number two from the complaint. Plaintiff is a high-profile prisoner of the Bureau of Prisons. He is a Grammy Award-winning recording artist and a nationally recognized celebrity. As with all prisoners, but particularly because of plaintiff's status, the United States of America, through the BOP, had a duty to protect plaintiff and his private and sensitive information to ensure that its employees did not exploit plaintiff for financial gain or for any other reason. The government's response. Admit the first two sentences. As to the third sentence, admit only that BOP has a statutory duty to protect the privacy rights of prisoners. Number three, states from the complaint, the defendant United States of America breached its duty of care to the plaintiff when it allowed countless BOP officers to access plaintiff's confidential information without any legal basis to do so. The defendant United States of America knew that BOP Officer A and other defendant John and Jane Doe BOP officers routinely assess plaintiff's private information from its systems and divulge private information to third parties for monetary gain, clout, or simply harassment. The government's response, deny. Plaintiff's complaint. Because of the United States of America's breach, at least 60 BOP officers made unauthorized access to plaintiffs' sensitive, confidential, and private information maintained by the BOP on its electronic system known as TrueView. Some of those BOP officers either shared and or sold that information to third parties, including members of the media and witnesses in plaintiff's criminal prosecution. Response from the government: deny. Number 5, complaint. Defendant unknown BOP Officer A accessed plaintiff's private BOP records. TrueView records, including email communications, visiting lists, inmate trust account information, and recorded phone calls with third parties and plaintiffs' attorneys without authority to do so. The information was private and concerned personal matters. It was not public information. After unlawfully accessing the foregoing protected information, Defendant BOP Officer A unlawfully downloaded the information and sold said information to Defendant Kiwi, a popular YouTube blogger with over 1 million subscribers, who published the private information publicly without identifying how she received it. The government's response: defendant lacks knowledge or information sufficient to form a belief about the truth of the allegations in this paragraph. Accordingly, they are denied. Number 6 from R. Kelly's complaint. Defendant Kiwi rallied her massive following to harass the plaintiff with the use of stolen information and created chaos in plaintiff's personal life, even using the information to influence witnesses in plaintiff's EDNY criminal prosecution. On information and belief, the stolen information was shared with and used by prosecutors from United States Attorney's Office as a tool to influence witnesses against plaintiff. The sale of the information yielded profits that neither defendant BOP Officer A nor defendant Kiwi were entitled to, and which belonged to the plaintiff, if anyone. The government's response: defendant lacks knowledge or information sufficient to form a belief about the truth of the allegations in this paragraph. Accordingly, they are denied. Number 7 from plaintiff's complaint. The Defendant of Justice Office of the Inspector General investigation initiated a secret investigation into the unauthorized access of plaintiff's sensitive information. The department did not inform plaintiff of the investigation and neither has. Plaintiff later learned that the investigation resulted in the issuance of a search warrant for BOP computer used by defendant BOP Officer A and forensic analysis of the computer. The government's response: as to the first sentence, admit only that there was an IG investigation into the unauthorized access of plaintiff's sensitive information. Deny the second sentence. Defendant lacks knowledge or information sufficient to form a belief about the truth of the allegations in the third sentence. Accordingly, they are denied. Number 8 from plaintiff's complaint. According to an affidavit of Special Agent Matt Louse of the Department of Justice, later obtained by plaintiff's attorney, probable cause existed to believe that defendant BOP Officer A committed a criminal violation, and of course, they cite this, that is unauthorized access of a computer to obtain information from the Federal Bureau of Prisons. No charges were brought against defendant BOP Officer A, and the government has refused to reveal any details about the investigation, including the identity of Officer A. In short, there has been a cover up of the rampant BOP misconduct that is ongoing. The government's response: admit that no charges were brought against BOP Officer A. Deny the remainder of this paragraph. They're going to deny every damn thing. Number 9, plaintiff's complaint. Even after this so-called investigation, unlawful access of plaintiff's true view records continued. Even after being put on notice of repeated violations of the CFAA by BOP employees, the United States failed to protect plaintiff and breached its duty to protect his private and sensitive information. The government's response: deny. Number 10, the plaintiff's complaint. For example, defendant unknown John or Jane Doe BOP officer made an unauthorized access to plaintiff's true view records and obtained information about plaintiff's trust account funds in August of 2022. That unknown defendant BOP officer divulged the information to a journalist for the Washington Post who published the personal information. The publication not only placed plaintiff in a false light, falsely suggesting he was concealing his resources, the monies were actually generous gifts from his loyal fan base, but resulted in the DOJ confiscating nearly all of plaintiff monies held in his prison trust account, over $25,000. Plaintiff was forced to pay for legal services to litigate the unjustified taking of the money, an issue that is now pending before the Second Circuit Court of Appeals. Plaintiff maintains that DOJ had no authority to confiscate those funds, which would not have occurred in any event if the information was not leaked to the public by a defendant unknown John or Jane Doe BOP officer. The government's response: deny. Number 11 from plaintiff's complaint. Defendant BOP officers committed the torts of invasion of privacy, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton misconduct. The defendant BOP officers, including defendant BOP Officer A, also committed violations of the Computer Fraud and Abuse Act. The government response: deny. Number 12 from plaintiff's complaint. Plaintiff suffered a multitude of loss and damages as a result of the defendant United States of America's negligence and the torts committed by defendant BOP Officer A and other unknown John and Jane Doe BOP officers, including but not limited to legal fees and emotional and psychological distress. The government's response: denied. Number 13, from plaintiff's complaint. Separately, losses in excess of 5,000 accrued as a result of the CFAA violation committed by defendant BOP Officer A. The misconduct resulted in international investigation. This misconduct resulted in an internal investigation by the BOP, an investigation by the DOJ, OIG, and both the seize and examination of a BOP computer hard drive. The government's response: admit that there was an investigation into the alleged misconduct of BOP Officer A, which included a search of a BOP computer. Denied that BOP Officer A violated the CFAA in furtherance of her official duties. Defendant lacks knowledge or information sufficient to form a belief about the truth of the remaining allegations in this paragraph. Accordingly, they are denied. Government. Jurisdiction and venue. Number 14 for plaintiff's complaint. The court has subject matter jurisdiction over this matter pursuant to 28 U.S.C. Section 1331, in that this action arises under the laws of the United States of America and is premised on the acts and omissions of the defendants acting under color of federal law. The government's response: deny that this court has jurisdiction under 28 U.S.C. Section 1331. Damn, government, something there. Number 15 from plaintiff's complaint. This court further has subject matter jurisdiction pursuant to 18 U.S.C. Section 1030G, which permits an individual who suffers damage by reason of a violation of the CFAA to bring a private cause of action. The action is timely filed where it is brought within 2 years of the discovery of the damage. The government's response: deny that 18 U.S.C. Section 1013G waives the United States sovereign immunity for the stated claims. Number 16, a plaintiff's complaint. This court further has subject matter jurisdiction over this matter pursuant to 28 U.S.C. Section 1346B, where plaintiff sues the defendant United States of America for money damages for injury caused by the negligent and wrongful acts and employees of the government while acting within the course and scope of their office or employment under the circumstances where the defendant, as a private person, would be liable to the plaintiff. The government's response: denied that the court has jurisdiction over tort claims against the United States in this case. My computer is acting up. I'm sorry, guys. Okay. Number 16, plaintiff's complaint. Jurisdiction founded upon federal law is proper in that this action is premised on federal causes of action under the Federal Tort Claims Act, pursuant to 28 U.S.C. Section 2671. The government's response: deny that the court has jurisdiction. Number 18 of plaintiff's complaint. Pursuant to the FTCA, plaintiff filed a notice of claim on November 14, 22, and served his claim to the appropriate federal agency for administrative settlement under the FTCA, requesting $1 million or more. The government responds: admit. Number 19 of plaintiff's complaint. By letter dated June 15, 2023, plaintiff's claim was denied in writing by the North Central Regional Office of the Federal Bureau of Prisons, and such denial was sent by certified mail to the plaintiff's counsel, and it puts the claim number. The government's response: admit. Number 20, plaintiff's complaint. This action is timely pursuant to 28 U.S.C. Section 2401B, in that it was presented to appropriate federal agency within 2 years of the accrual, and this action was filed within 6 months of the receipt of the certified letter sent by the federal agency denying the claim. The government's response: admit. Number 21, plaintiff's complaint. This court also enjoys supplemental jurisdiction if necessary under 28 U.S.C. Section 1367 in connection with the claims against defendant Kebe, who, if not acting as contractor for the federal government, is liable for claims that are so related to the claims in this action within such original jurisdiction that they form part of the same case or controversy. The government's response: Defendant takes no position on whether the court has supplemental jurisdiction over the claims against defendant Kibi. Number 22, plaintiff's complaint. Venue is proper in this district pursuant to 28 U.S.C. section 1391B and 1391C. As defendants do business in this judicial district, and a substantial part of the events giving rise to the claim occurred in this jurisdictional district. The government's response: defendant lacks knowledge or information sufficient to form a belief about the truth of the allegations in this paragraph. Accordingly, they are denied. The cited statute does not apply to FTCA claims, which are governed by 28 U.S.C. section 1402B. Admit that venue is proper for acts or omission that occurred in this district. Okay, parties. Plaintiff's complaint number 23. Plaintiff Robert S. Kelly is a 56-year-old Chicago native. He is indisputably the king of R&B. He is currently an inmate incarcerated at the Butner Federal Correctional Center in Butner, North Carolina. At times relevant to this complaint, plaintiff was an inmate at the Metropolitan Correctional Center in Chicago, Illinois. The government's response: admit that plaintiff is 56 years old and a well-known R&B musical artist. Admit the third sentence. Admit that plaintiff was incarcerated at the MCC Chicago from July 11, 2019 to August 1st, 2019. August 7, 2019 to June 22nd, 2021. July 12, 22 to April 19, 2023. He was incarcerated at the MDC Brooklyn from August 1 to 7 in 2029 and June 22nd, 2021 to July 12, 2022. Defendant lacks knowledge or information sufficient to form a belief about the truth of the remaining allegations in this paragraph. Accordingly, they are denied. Number 21, plaintiff's complaint. Defendant, United States of America, is subject to suit for injury caused by the negligent and wrongful acts and omission of employees of the government while acting within the course and scope of their office and employment, under the circumstances where the defendant, if a private person, would be liable to plaintiff pursuant to FTCA. The government response: admit subject to any and all limitations and requirements of the FTCA. Number 25, a plaintiff's complaint. At all times material to this action, unknown BOP officer, known as Officer A, was a federal BOP disciplinary hearing officer and law enforcement official employed by the BOP with access to the BOP's True View system. Although plaintiff does not know the true identity of Officer A, the BOP does. She is the officer identified in the search warrant application and the affidavit of Agent Matt Louse that was provided to plaintiff by the U.S. Attorney's Office in June 2022 during plaintiff's prosecution in the Northern District of Illinois. Government's response: admit. Number 26, plaintiff's complaint. At all times material to this action, unknown John and Jane Doe BOP officers were BOP officers assigned to the Chicago MCC and perhaps other BOP institutions with access to the BOP's True View system. Although plaintiff does not know the identities of the 60 different BOP officers who made unauthorized access to his confidential information, the BOP does. Plaintiff sues each and every BOP officer who has accessed his confidential information without authority and whose identities are available from the BOP. The government response. Defendant lacks knowledge or information sufficient to form a belief about the truth of the allegations in this paragraph. Accordingly, of course, they are denied. I don't even know if I should finish reading this shit, guys, because they denying every damn thing. Okay, let me see. Let me see. Number 27, R. Kelly's complaint. At all times relevant material to this action, Latasha Kebe is a resident of Lawrenceville, Georgia. Kebe is a popular YouTube host with a YouTube channel called Unwind with Tasha K. She broadcasts content to 1.3 million subscribers across the country, including in Chicago. The government's response. Defendant lacks knowledge or information sufficient to form a belief about the truth of the allegation in this paragraph. Accordingly, they are denied. Facts. Plaintiff's complaint. Plaintiff was arrested in the United States District Court, Northern District of Illinois, on July 11, 2019, in connection with a 13-count indictment in United States versus Kelly. Shortly, of course, there's the court number. Shortly thereafter, plaintiff was separately indicted in the United States District Court for the Eastern District of New York in connection with RICO charges brought under case number, you know, the case number for New York. The government's response, admit. Number 29, plaintiff's complaint. After his arrest, plaintiff was detained in the Metropolitan Correctional Center in Chicago for nearly 2 years until he was transferred to the Metropolitan Detention Center in Brooklyn to face trial in the EDNY case in and around June 21, 21. During this period of time, plaintiff was a pre-trial detainee. Government's response. Admit that plaintiff was pre-trial detainee during this time. Denied that he remained at MCC Chicago from July 11, 2019 to 2021. As explained above, in response to the paragraph 23, he was incarcerated at the MCC Chicago from July 11, 2019 to August 1, 2019, August 7, 2019 to June 22nd, 2021, July 12, 2022 to April 19, 2023. He was incarcerated at MDC Brooklyn from August 1 to 7, 2019, and June 22nd, 2021 to July 12, 2022. Number 30. R. Kelly's complaint. While detained in the MCC in and around January of 2020, plaintiff's longtime girlfriend, Jane Doe, began behaving in a hostile and accusatory fashion toward the plaintiff without explanation. Jane Doe was furious with plaintiff and unexpectedly began causing stress and conflict in the relationship. These arguments related to money issues, romantic issues, and other highly personal issues. Plaintiff later learned that in and around that time, Jane Doe abruptly began cooperating with the government, which led to her becoming the government's star witness against him in the EDNY prosecution. The government's response. Defendant lacks knowledge or information sufficient to form a belief about the truth of the allegations in this paragraph. Accordingly, They are denied. Ooh, they lying as you know, they, oh my God. Number 31 for plaintiff's complaint. In and around that time, Defending Kibi, a popular YouTube blogger, began publishing information to her 1.1 million subscribers and other viewers' private information about the plaintiff to which she should not have had access. Defendant Kibi did not reveal how she received some confidential information. The government response. Defendant lacks knowledge or information sufficient to form a belief without the truth of the allegations in this paragraph. Accordingly, they are denied. You know what? I'm ending this shit right here because they're denying everything, and I'm only rereading something that I've already read, which is R. Kelly's complaint. So just so you guys know, this is the government's answer. Tasha K has not filed her answer yet. So I'll keep you guys updated when that happens. Wait a minute. It's something else I want to share that I saw that was filed. Hold on. But if you guys want a copy of this, I'm not, it's because they're going to deny this. I mean, this is typical complaint response from a defendant, to be honest with you. You're either going to admit or deny. You know what I'm saying? So, and they only admitting to what we already know that's already of record. And the rest is just BS. So, but if you, again, you know, I don't mind. And just so you guys know, when I say I will provide you with a copy, I'm speaking to my loyal subscribers, not you people that's just hopping in for a hot second and just think, you know, you can just come over here and just get what you want. It doesn't work like that. If you're not a subscriber, I'm not providing you with documents that I receive. I'm sorry, no hard feelings, but this is to my loyal people that sticks by me, that's actual subscribed to my channel and not just hop over when I come on and maybe not even give me a like. You know what I'm saying? So hold on one second. Let me get this other document. Okay, the other document is a Rule 26F planning report. Now, this was filed. Who filed this? Let me see who filed this. This was also filed on the 5th. Let me see who filed. Oh, Jennifer filed this. Okay, here we go. Rule 26F planning report. Number 1, meeting. Pursuant to Federal Rule of Civil Procedure 26F, a meeting was held by phone on February 2nd, 2024, and was attended by attorneys Jennifer Bonjean and Ashley Cohen on behalf of plaintiff and a USA Alex Hartzler on behalf of the United States. Number 2, pretrial schedule. Plaintiff and the United States jointly proposed to the court the following discovery plan. Here we go, baby. Plaintiff to amend pleadings by August 5th, 2024. Plaintiff to add any additional parties by August 5th, 2024. Defendants to amend pleadings by September 7, 2024. Defendants to add any additional parties by September 7, 2024. Now, this is the good part. You know how I was telling you they have to answer their complaint, depositions have to be taken. So this is where the discovery part comes, and that's number 3. So we're going to get to the bottom of what's going on here. Whoever the hell BOP, that all of you people that's been dismissing and thinking that was nothing, is dead. It's not. It's not. It's about to really happen, baby. They got to reveal it. So number 3, discovery. Plaintiff anticipates seeking discovery on at least the following subjects. Listen to this, guys. The identities of the unnamed defendant Bureau of Prison officers, the officers' conduct during the relevant time period, the BOP's investigation into the alleged conduct, and the alleged circulation of plaintiff's private information. A, disclosure pursuant to Federal Rules Civil Procedure 26A1 to be made by March 4, 2024. Fact discovery to be commenced in time to be completed by March 4, 2025. B. Plaintiff and the United States anticipate that plaintiff may need more than the standard limit of time. The standard limit of 10 depositions per side. Okay. Plaintiff and the United States will work together to try to stipulate to a reasonable amount of depositions without requiring the court's involvement. C. The unusual nature of this case, the currently unknown number of defendants, and the sensitivity of the subject matter underlying the allegation makes it difficult to predict the precise course of fact discovery. For example, it is unclear how long it would take to identify the total number of BOP officers who had involvement in the alleged conduct. It is equally unclear whether all, some, or none of those officers will be presented by the United States, the U.S. Attorney's Office, or if they will retain private counsel. Issues regarding the sensitivity of internal BOP policies and investigations may also delay the progress of discovery. Plaintiff and the United States will work together cooperatively to address these issues, but in light of these uncertainties, they request that deadlines for expert discovery, depositive motions, and pretrial filings be set closer to the close of fact discovery. Settlement. Number 4. Prior to the filing of this lawsuit, plaintiffs submitted a written settlement demand to the United States, and the United States responded in writing to the plaintiff's settlement demand. Number 5, consent. Plaintiff and the United States do not consent unanimously to jurisdiction by the assigned magistrate judge. Respectfully submitted, my girl, Miss Jennifer Bonjean, and then you had Alex Hartzler sign on behalf of the government. So that's that, guys. So it's on. So and if I'm not mistaken, I could have sworn I saw something recently where Tasha K actually was basically talking about what this complaint R. Kelly filed. And for some reason, she dismissed it like it was like it was over. No, babe, check this out. It's just beginning. So that's why I tell you guys, stop listening to all these people some of these people on these panels, baby, because they don't know. No, how you gonna just dismiss? No, it doesn't work like that. So if you guys would like a copy of that planning report, your girl got you. So just let me know. But that's it. And I do apologize that I read some of that answer. But, I usually don't even deal with anything from the damn government anyway. But the way it was reading, and it was just consistent. I'm reading a complaint I've already read, what we had in the complaint, and they're just denying or admitting. So it's not all of that. So if you guys, like I said, if you wanted to finish it off, absolutely. And if you want the planning report, I got you. Okay? And that's all I have for you today. Enjoy the rest of your day, guys. Bye-bye.